Calling this work session to order. We'll do a roll call. Ms. Camacho.
Ms. LaFrance.
Here.
Ms. Salato.
Here.
Mr. Rivera.
Here.
Ms. Kennedy.
Did I hear Kennedy?
Yes.
Okay, yes, I'm here.
Mr. Dunbar.
Here.
Mr. Weddleton.
Here.
Mr. Peterson.
Present.
Mr. Constant.
Here.
Ms. Quinn Davidson.
Here.
Mr. Perez Verdia.
Here.
Mr. Dyson.
Here.
Wonderful. Ms. McClawson, has that email gone out yet? Perfect.
Yes.
So
Yeah.
you all should have another copy of the S version in your inbox. Ms. Vogel, would you please discuss this item with us?
Thank you, Mr. Chair. What this ordinance does is give the municipality powers similar to powers that exist in state law to respond to a public health emergency like the one we're facing now, and specifically to respond with requirements for testing and with the possibility of ordering quarantine or isolation. One word on that terminology, which maybe everyone is familiar with by now. Quarantine might sound scarier, but quarantine is for people who are exposed. Isolation is actually the more restrictive setting, and that's for people who are infected with a disease. Anyway, this very much models the state version, and we, in looking at it, had looked at a couple things: state law, and then some model quarantine and isolation code that was available to us. And after consultation with important state partners, including the state court system, we determined that it would be wiser to adhere as much as possible to state law, because the only time that this is likely to be implemented is in an emergency situation. And in that emergency situation, superior court judges who are hearing cases brought by the state will be trained in one particular way. Any deviation that we make from state law is something that we'll need to be prepared to justify, and is also a possible source of liability for us. And the notion behind having concurrent jurisdiction with the state on this is just when there is a pandemic or a public health crisis that is statewide, the municipality has additional resources that it can add to the state's existing resources to respond, and it allows us to potentially respond more nimbly than if we were waiting on one public health official from the state. So it's hopefully something we don't need to use, or even in a situation where there is quarantine required, maybe state capacity will make it so that we do not need to use our particular municipal powers. But in a rapidly developing situation, we thought it was a good idea and didn't see much downside to having that as part of the powers in our toolbox. Oh, I'm sorry, one last thing, which is to clarify, we believe that this power already existed under, that it's well within emergency powers, but felt that it was a good idea to specify it, particularly because there's a lot of process that should go along with any such orders, and since it can be spelled out, and that helps everyone, attorneys, people facing the court system, people who are trying to decide whether to comply voluntarily or challenge it, spelling it all out in code really helps make that be a process that can be used, rather than something that people are scrambling at and maybe don't have as much knowledge about due process balancing as if we have this time now to put it all into code. So that's the motivation behind it, and a lot of the wording choice as a result is copying state law, and so for that reason our request is to minimize corrections to the part that copies state law, unless we think it really adds clarity or something that we want to defend the difference in court.
Thank you. Mr. Peterson, and then Ms. Zalato.
Thank you, Mr. Chairman. And so if someone wanted to challenge an isolation order and the courts weren't meeting, how would they go about that?
Through the chair, Mr. Peterson, the courts have indicated that, and they've already continued a bunch of different hearings. They've indicated that quarantine and isolation orders are one of the ones that are going to remain absolute priorities. So we have an understanding from the court system, and I've now had 3 different meetings with representatives of the court system. And we understand from them that they intend to keep the court open for this type of hearing as well as some other very crucial hearings.
Okay, great, thank you.
Thank you, Mr. Peterson. Ms. Zolotel.
Thank you, Mr. Chair. Can you walk me through a little bit, just kind of play out a scenario or two, particularly on how we expect the ex parte orders would go? And I need to understand how this would work in operation.
Through the chair, Ms. Zolotel, I envision that there are elements of this that are similar to mental health commitments. If you're familiar with those, some of the standards in here are quite similar to the mental health commitment process. But essentially what would happen is, let's say we have a positive test result, and we ask the person if they're interested in voluntarily complying with quarantine. They say no. We say, all right, we are going to go through our official process and order you to be under quarantine, or sorry, if they've tested positive, then we're talking isolation. And then they are now under an actual order, starting at the moment that we officially order it. Again, we want not to go to the stage of issuing an ex parte order unless they're not interested in voluntary compliance. So then we have the power of law behind us, and now we have 24 hours to file a petition with the court. That petition explains why the individual should be in isolation or in quarantine. The court, from the time that it receives that petition, has 48 hours to hold a hearing determining whether or not the municipality has correctly exercised its power, and deciding whether or not the quarantine continues or is lifted.
So if I'm understanding correctly, then it's a total of, was that 7? If I track the math right, if it's contested, it's 72 hours until such time as any actual action would be taken because of going through the court proceedings?
Through the chair, no, I think 72 hours is the maximum amount of time it could take from the moment that you've been issued an order to the moment that you have had your day in court.
Okay, so because some of this, because we're adding the screening language, I just want to make sure I understand. So someone could contest even being screened. Then if the judge issues an ex parte order, then that person gets to request a hearing. And then it says in subsection 4 on page 4, if I've got this right, that the individual, the court shall hold a hearing within 3 working days after the date the request is filed. So, and that's in the original text, not part of the amendment. So it seems like even if an ex parte order is obtained, that the actual action may still be delayed for a fairly significant period of time.
Through the chair, Ms. Zolotel, what we understand from our communication with the courts is that the rationale behind asking for a judicial officer rather than the superior court to act in that instance, which again models state law, will enable us to use magistrate judges who can respond quite quickly and are accustomed to responding quite quickly in warrant type situations. So we anticipate it not taking that long.
Okay, thank you. I might have another follow-up in a minute. Thanks.
Thank you, Ms. Zolotel. Mr. Constant?
Thank you.
I have a question about the fundamental premise behind this thing. And if you look at page 2, line 5, it's section A, and assume that it's not us implementing this code. It's many years down the road, and some less honorable crew of people are sitting in these public seats. And I wonder if abuses might not, in fact, be possible with this language as it's written, because it says the appearance of a novel or previously controlled or eradicated infectious agent. Couldn't that be a common rhinovirus? A cold.
Through the chair, but it requires at the top of that public health emergency means an occurrence or imminent threat of an, well.
It's the and at the end of the one that does it in section 2. Because a cold wouldn't pose.
Yeah, sorry, I'm now reading and trying to see if there's anything that makes it extreme. Yeah, so right, right, it's
like
the and at the end of one.
No.
So yeah, so for the first part 1 just requires that it be sort of new. It describes a whole category of things, but then you've got an and now we start requiring it not to be just the common cold, but do the things that are listed in 2, posing a high probability of any of the following harms, and those include a large number of deaths, a large number of serious or long-term disabilities in the affected population. Or widespread exposure of infectious or toxic agent that poses a significant risk of substantial future harm to a large number of people in the affected population. And we didn't make up this wording, as you're probably not surprised to hear. We borrowed this one.
Where did you borrow it?
From the state.
State.
I'm going to defer to Quincy here if this came from the state or from the model code.
The definition?
Yes.
All right, thank you.
Thank you, Mr. Constant.
I can't remember.
It's from one of those 2 models, and we can get back to you if you're curious about which model code we borrowed that from.
Yeah. But I think Mr. Constant's point is still well taken. Like we have to be careful about the kind of powers we put into code. I mean, there's no question. Ms. Zalatel?
Thank you, Mr. Chair. So as I was reading through the procedures for ex parte orders again, I am really familiar with the mental health ones. It's what part of my day job is. There's no appointment of counsel, am I correct, for the person who is subject to the ex parte order and has maybe requested a hearing?
I'm sorry, I interrupted. I was speaking with Ms. Vogel. Could you repeat that, Ms. Zalatel?
Sure. The question is there any appointment of counsel for the individual? Because I'm not seeing that in the ordinance.
Through the chair, no, there is not in this ordinance appointment of counsel, nor in state law, but there's certainly an expectation under, I think, case law that it's required because of the due process implications.
Yeah, that's really very concerning to me because, it's really concerning to me that it's not explicit in here, because even if it's for purposes of screening and the person chooses to contest the ex parte order, they could be taken into protective custody. So we could be significantly curtailing their liberty without potential representation unless the 7A-C reference is, or there's some cross-reference in here that makes that explicit. It's a significant concern of mine.
Do you have any thoughts on that, Ms. Vogel?
Through the chair, I think we could add some more explicit reference to counsel, because it's certainly the intent that there will be that there is a right to counsel.
Okay.
Great, thank you.
Can we? Who is going to actually write up that amendment? What's that?
I can.
Okay, so Ms. Arms, you'll write it up and maybe work with Ms. Zalatel on it?
Sure. You want a floor amendment?
I think a floor amendment is probably the best way to go. We already have an S version,
Yeah.
so I don't really want an S1 if we can avoid it. Ms. Kennedy? Oh, I'm sorry, Ms. Kennedy, before you go, Mr. Peterson was in the queue. Mr. Peterson?
Sure, go ahead, okay.
All right, thank you, Mr. Chair. And so I was just saying, so if someone that contested the order, they would get a standard, if they were taken into custody, they would get a standard Miranda warning or not? Or is that something we need to add in an amendment? Because that guarantees them right to counsel, right?
Ms. Vogel, you want to speak to that?
Through the chair, Miranda warnings are very specific to the criminal context about what an individual, lets individuals know that what they say can be held against them in a court of law. That is very different from the civil commitment context, which is, I think, the most analogous to this. One of the differences is, the criminal context really only protects society at large, and it is punitive in nature. What this does is it's not intended to be punitive in nature, and it often can go for the protection of both society at large and the individual themselves. As a result, the whole legal structure has very different protections. There will be, I anticipate, some forms that are given to folks, and we are going to align with the state in trying to have similar content in those forms that lets them know all of their due process rights. And this is a process that has significant court oversight, which I think is also going to be very protective. As for Miranda warnings specifically, no, it doesn't include those, and I don't think that those would be appropriate.
Okay, thank you.
Yeah, and actually, for the benefit of the broader public and us not very good attorneys, can you explain what exactly an ex parte order is, what that means?
Sure, Mr. Chairman, an ex parte order is one that occurs at the request of one party without the other party being present.
Okay. And it's a court order that has legal effect to take some action.
Correct.
Ms. Kennedy, you're in the queue.
Thank you, Mr. Chair. I'm having a lot of trouble with all of this just from the very beginning, and that is in section 2, page 2, let's see, I guess that would be line 44. The very beginning of this starts out with special powers, and during a state of emergency, the mayor, and I can appreciate the fact that they've changed the verbiage from shall to may, but the phrase used, every available means, is so broad and so all-encompassing. And when I think about what that could look like, that is terrifying. And to say that we're going to give the power to any mayor for however long this municipality is in existence to use every available means to combat or prevent the transmission of any infectious disease is absolutely a door that I don't believe we can even begin to try to open. There's no checks and balances in this. There's really no way for the assembly to really even weigh in. I mean, certainly there could be, but I mean, when I start to thinking about what that actually could look like, I mean, could the mayor, in order to make somebody comply, could they begin to shut off their power and their water in their home? Could they limit access to food for the population? Could they actually authorize deadly force? Anyway, that, just for that very reason of those few little words there, I can't even get past that part to even begin to look at everything else that is basically being suggested. So I don't know if we want to have a conversation about that, if there is a way to contain that particular sentence, or to try to draw it down to something a little less broad. I really can't really have much more of a conversation about the whole entire ordinance amendment. So I'll just put that out there and see if anybody would want to offer some suggestions, but I cannot in any way, shape, or form say that we're going to give any one person, the idea of using every means available to prevent infectious disease.
Thank you, Ms.
Thank
Kennedy.
you.
Ms. Vogel would like to answer that, and then we have in the queue, we have Mr. Dyson and Mr. Constant. Ms. Vogel?
Through the chair, Thank you. I recognize that concern, but and I feel like it feels like it's a stronger sentence when you water down the meaning of public health emergency, and then you're just looking at the words infectious disease. But the words public health emergency are in here, and they mean it's not any infectious disease. It's a particular infectious disease that is causing imminent threat, and it has all the requirements of Part 2. A high probability of a large number of deaths in the affected population, a large number of serious or long-term disabilities in the affected population, or widespread exposure to an infectious or toxic agent that poses significant risk of substantial future harm to a large number of people in the affected population. So I understand why that sentence, when all of the meaning of public health emergency is written on another line, can feel like it's applying to more situations than it is. Secondly, the checks that are provided by the Assembly are twofold. One is an existing code, which would allow the Assembly to end the emergency at any time. Also, the emergency couldn't last for more than 48 hours without Assembly approval. And the second is a proposed ordinance, which would allow the Assembly, and this proposed ordinance is, I believe, going to be on the agenda for introduction at the special meeting on Friday. And it would allow the Assembly to terminate any specific emergency order or regulation of the mayor. So that would be not having to end the whole emergency, but ending a particular order or regulation. And those are two available checks. So I think it applies to a smaller subset of cases, and I think that it does have some checks. And then the last thing is, we're drafting it with the current COVID-19 obviously on our minds, but there's also, what if it was Ebola? What powers would you want the mayor to have if that was the case? And so we've got checks and balances, but the notion of it, of not having the power to use available means to stop the transmission, why are we leaving available means on the table if it is that kind of devastating, sudden pandemic?
Mr. Chair?
Yeah, Ms. Kennedy, a follow-up to that?
Yes, please. I'm not arguing anything about the when you might want to have this capability in terms of what kind of infectious disease you might be trying to address. What I'm arguing is the whole idea, the concept of giving someone the ability to use every available means. So my question, I guess, would be very pointedly, are you suggesting that we should be giving the mayor the ability to use deadly force to stop people from, in whatever way, shape, or form the mayor believes that this disease is being spread, that we should actually allow that in an effort to stop the transmission of disease? So I want to know, I want a definition, or what would be the limitation to that phrase, every available means. Thank you.
Thank you, Ms. Kennedy. Mr. Dyson, and then Mr. Constant, Ms. Zoloto.
Yes.
Wait, shouldn't we get an answer to that question, though, about deadly force?
Let me speak to it if I may.
Okay, and then Ms. Vogel will give you a chance too. Mr. Dyson?
Yeah, and Ms. Vogel, you completely missed Ms. Kennedy's point, and I'm glad she came back on and did it. The same sentence bothered me. I think what we need to do is insert after, on line 41, after use every, insert the phrase reasonable, responsible, or appropriate. I think reasonable has meaning in law and so on. And I think that addresses Ms. Kennedy's very valid concern.
Ms. Vogel, do you want to speak to that?
I have no objection to the word reasonable being used.
Okay. If that's, okay. So, Mr. Dyson, did you have any other question?
No, sir.
Okay. Mr. Constant?
Okay, so to put that fine point back on it, like hear an answer from the municipal attorney and the administration, does this assert that it is the mayor's single authority to commit homicide in order to save lives?
Through the chair, no, I don't think that that's what this does. I mean, our police officers go out every day and are in all sorts of situations where questions of use of force are scrutinized by courts and evaluated. Use of deadly force is always a tragedy. That is not what is being contemplated here in any way that is different from everything else that we do, where we send out someone in armed uniforms. And in fact, one of the things that we have done in this ordinance is say not only do we have criminal penalties for violations of this, but which is already existing code, which says violating an emergency order is a criminal penalty, and that's where maybe you think about the police being the ones who respond. We've also proposed that there be. Am I correct that we're doing it in this one? I should double check with Quincy. Right? We put it in here, right? The penalty change. Yeah. Okay. So the penalty change made it into this version. We're just.
Yeah, on the second to last page, you delete section 11 about being a misdemeanor.
Yeah, and so it also allows concurrent civil penalties, which means that we can be sending out code enforcement and individuals who are much more likely to de-escalate a situation. The administration is really interested in de-escalating situations while at the same time not losing the ability to respond nimbly to a public health emergency.
But how do we bound the term any or every available means? How do we bound that? Because this is boundless power that we're granting as long as it's justifiable by some reason. I have some people who have suggested that maybe we should use the term every scientifically justified means, or some kind of measure that bounds within the response that we're talking about. But every available means is an extraordinary reach.
Ms. Vogel, do you want to speak to that?
Yes, through the chair, Mr. Constant, two things. One is we have no objection to it saying use every reasonable means. So I think that would change the wording that you're particularly troubled by. And secondly, the Constitution of Alaska and the Constitution of the United States are still in full
Constitutionally
force.
allowed.
You would think so, but under emergency powers, all of these things change. And the courts will have deference, and there will just be different rules established, especially when you find yourself in alignment between local, state, and federal courts, that we are in an emergency. It probably, this is just a guess, I'm not a Yale attorney, but it probably is easier to make the case all the way up to the Supreme Court that we are using reasonable means when we're trying to stop this because we were in an emergency. And that's where the words matter, I think, now.
Do you have any follow-on, Ms. Vogel?
Through the chair, I agree that the power of municipalities, states, and the federal government is higher in times of emergency. It is higher, and under the Constitution, it's already higher just by there being a state of emergency and existing code and what it allows. There is oversight. There's oversight by the Assembly. There's oversight by our court system, and the rationale is pretending that there isn't an emergency happening and that all of the normal processes that we expect in a non-emergency situation to apply to a state of emergency would often not result in the protection of public safety and the people that the people demand from government. I mean, that's why there is emergency powers. And that's why it's important for there to be open discussion about it, like we're having here, and the ability of the Assembly to provide a check, and and we're talking about elected leaders who are responsible to the people as well. So I understand the concerns. I think some of them are not about this ordinance at all, and I hope that the word reasonable can help frame that, and as well as the fact that we're looking at civil enforcement as an avenue.
Okay. So, Ms. Zolotel, you had a question?
Thank you. Yes. Before we leave Section A, I disagree with the statement that we have oversight once this power is granted. And I would like to see there be some balance here, because what we've done to date in this particular instance is the mayor issued an emergency proclamation. We extended it up, a declaration. We extended it to a certain period of time. But if we pass this ordinance, Ms. Kennedy and Mr. Constant's concerns, I think, are real, and there's no automatic check on this power once it's granted. I understand it only applies in emergency, but right now, I have to say that I can request information from the administration, but I don't necessarily know everything that's going on. And it's not for want of trying. So this provision gives me great pause. So I will just share that. I will keep thinking about it and see if I can come up with an amendment or some balance there, but I'm not comfortable with it. My question, though, was I'm still working through the testing, screening, and examination portion of the ordinance. So I'm on page 6, I believe. My number got a little cut off when I printed it. I'm old school on paper, even at home. But Section F, isolation and quarantine, the idea here that the mayor could isolate or quarantine groups of individuals who have not been vaccinated, treated, tested, screened, or examined, how does that work, again, in operation? Because it would be would it be, if someone disagreed with that decision, then would there be ex parte orders still? Because it's the whole group. And then how would individual notice go to all affected in the group, and how would that actually play out? Thank you.
Through the chair, Ms. Zolotel, I'm imagining a cruise ship that is coming, and therefore we identify a group of people that we're talking about. And that's where you start talking about groups. The proposed code, like state law, suggests that where possible, and there are issues of law and fact in common, you might want to have one hearing that a judge is getting. So someone's representing the entire cruise ship group, for example, and deciding whether quarantine is appropriate. So I think that's sort of the vision of group settings. Otherwise, honestly, quarantine and isolation in this kind of way, where you're going to court, are really about otherwise small numbers of people. One person traveled, and you want to have something other than just a recommendation that they don't leave the hospital room in which they're in isolation. You want to be able to have force of law that says, nope, you are not allowed to leave. And because people ask, is this a requirement, or can I leave? And so sometimes just the fact of having a requirement can help protect the public good. But I think I've drifted a little bit from your question. Sorry. So I think that these are used mainly when it's a small thing that's not super widespread. I think the more widespread you get more blanket orders rather than that are not following quarantine and isolation.
So if there's, again, a reference back to state law, maybe we can that would make it a little more clear, or help me ground this in something, because I heard it referred to again. And I think it's interesting because we talk about a group or isolation and quarantine, we talk about groups in subsection F1. And then when we talk about procedures for isolation and quarantine in G, we only talk about individuals. And I'm finding a disconnect there between the provisions, because this suggests that each individual subject to isolation and quarantine actually has due process rights, but the group, there just seems to be a disconnect there. If you're a group of individuals, because then each of those individuals in the group, then do the procedures in G apply to them?
Through the chair, yeah, we were envisioning that they did apply to them. So if there are wording changes that we can talk about, I'd be happy to. That said, yeah, we are copying state law.
Because, yeah, the idea that, I mean, if your procedures for isolation and quarantine, it says that the mayor shall petition for a written order under the section in 1, and then it identifies A through I, and all of those are very individualized assertions that have to be made, and so I don't understand how that necessarily applies to an entire group unless you're just going to repeat it over and over and over again. So I think if you're intending for that procedure to also apply to a group, we need to reconcile the language, just so it's clear.
Through the chair, yeah, I think the idea is if you do know there's a cruise ship, you don't want to have to issue 500 separate orders.
That's exactly what I'm saying. So right now, if you take this ordinance at face value, you do, I think. That's how I read it, that G is the procedure, and you've only allowed it to be on an individual basis, I believe, if I've read it completely. It's all about an individual, and an individual, but I don't see how you get from F1 as this authorization for groups and then get into the procedures for isolation and quarantine in G without, it doesn't apply to groups. So we either need a procedure specifically spelled out for groups, or we need to make it clear what we're going to do when we do have groups. And beyond the cruise ships, I mean, I can think of other instances of where we may have categories or groups of people. So I want this to be really clear, and that we are really clear on their rights as to, especially if they may only get one set of representation. So I'm not comfortable with how this applies to groups right now. This is not my area of expertise, but I'm happy to work with Quincy or you on trying to figure out something, but I'm uncomfortable with it as it stands.
Through the chair, that sounds like it would be more productive is, working with Quincy. I would note that Part 3, G3, talks about a little bit about what the Superior Court would do with a group of claims, but that might not be sufficient to address your concerns, and I do think we'd be happy to make sure that it's clear.
Thank you, Ms. Solotel. We are. I've got a few people in the queue. Mr. Weddleton.
Thanks.
Got me there.
A couple things. One, going backwards a bit, sorry, but on the powers of the mayor. And, that is a concern. I appreciate Kennedy bringing it up. But if you read this thing, that one word says he has a lot of power, or she. But there's only 6 things that are discussed, and that's testing, screening, examination, treatment, isolation, and quarantine. And so everything following that, those are the only things that, the tools that are used. So I wonder to kind of asking Ms. Vogel if that section that says, any means possible could just more clearly say these 6 things.
For the record, we've been joined by the mayor and the chief of staff. Ms. Vogel?
Through the chair, I don't think that we want to say when it's a public health emergency, these are the only things that can be done. I point out this public health emergency, we've done things other than quarantine or isolation, which the municipality has not engaged in, and we do not have this code. So I would be really reluctant to limit powers that the mayor already has in code because it's a public health emergency.
Okay. John, do you have a follow-up question? I've got you.
No, I'll let that sink in.
Okay. I've got Ms. Kennedy, Ms. Dyson, Mr. Constant, Mr. Weddleton in the queue. Ms. Kennedy? Oh, I'm sorry. Actually, you know what? I did it again. I skipped Pete again. Mr. Peterson and then you, Ms. Kennedy. I apologize.
Thank you, Mr. Chairman. And I was just thinking, going back to section 2, the line 44, maybe it should say something like the mayor may use every special power enumerated in this ordinance to prevent the transmission of infectious disease. That would limit it to what is specifically mentioned in this ordinance. And would that make, Ms. Kennedy, would that make you more comfortable?
Mr. Chair, I'd have to look through the rest of this too, because I do have other concerns about the isolating and quarantining. And I think that, for me, it's kind of what it does come down to, is to what measures you're going to use to enforce that idea. So I can't necessarily say that doing that actually answers all the questions that I have in the rest of the ordinance. So, thank you.
Okay.
Thank you, Mr. Peterson. Ms. Kennedy, did you have a separate question in that?
Yes, I do. Thank you. And actually, kind of a comment and then maybe a question. But, in terms of how we might have the checks and balances that are considered reasonable in this, one of the problems with the assembly oversight is that it's really a slow process. I mean, we have to get together. We have to call a meeting. We have to decide that we're going to rescind something or change an order or whatever. And, and that does take time. And there's certainly, with the potential for being able to use every available means, the potential there is that a lot could happen. A lot of damage could actually be done before the assembly we didn't have the opportunity to react or respond. So, and in the same vein, I think the same is to be said of the court system. I mean, we're worried about overloading our hospitals in all of this. I can't imagine what we would be doing if we're going to start to establish ways for people to go through the court system to oppose any of these quarantining and isolation orders. So anyway, the whole thing just gets more and more problematic the more that I look at it. So I'm not sure what the answer is to try to put it into that reasonable balance status. But I'm certainly going to be continuing to look at some of this. But I do think that as it is right now, there's no way I would pass it. Thank you.
Thank you. Mr. Dyson?
Yeah, thank you. On page 9 of the line 41, I asked Mr. Gates if he would like to produce 3 related subparagraphs here. So they'd be 12, 13, 14. 12 would say knowingly exposing others to the disease, recklessly knowing and recklessly exposing others to the disease would be a Class A misdemeanor. Knowingly
Which version are we looking at?
Knowingly transmitting the disease would be probably a Class B or Class C felony. And the last one is that causing death or permanent disability of the recipient of the disease would be an aggravator in sentencing. So anyway, you guys can discuss it or respond to it if you want. Maybe Mr. Gates will.
Is that page 10?
Does it?
No, I thought it was, are you talking about page 9 or page 10?
I'm sorry, page 10. No, page 9.
Ms. Vogel, do you want to speak to that?
Through the chair, thank you. Mr. Dyson, one of the concerns about knowing and like having a specific new crime for knowing and recklessly exposing is what to do with family situations where you would have, for example, a parent who knows that they're positive, caring for their child, and I think there are some concerns in infectious diseases and how it plays out in family. But there is also current criminal law that for the sorts of conduct that we are thinking about might be able to already come into play and criminalize the sort of, I think we all are imagining going into a, you're infected, going into a bar, trying to spread it to other people. Yeah.
But I understand that the context here is that the state is not going to, doesn't have the resources to prosecute this. And I want the city to clearly have it. And setting the standard in the city ordinance is a part of the educational process of statute law. So, following number 11, it's kind of appropriate in its talking about enforcement.
Okay, thank you. So I have, in the queue, I have Mr. Constant, Mr. Rivera, and Ms. Zalatel. Mr. Constant?
So anywhere in here in this document, do we provide notice to the subjects of it that they have a right to go to the courts? And how is that process established to work here?
Ms. Zougal is looking through her ordinance right now.
Through the chair, I'd like to have, I'm unable to sort of identify what the notice provisions are sort of on the fly, but I'm happy to look into whether we specify all of the notice rights. I'm not sure that our code normally does, and that doesn't mean that notice doesn't happen. Yeah.
If I might, there are places in the past where we have specifically stated that something happens with notice.
Thank you, Mr. Constant. Okay. Mr. Rivera?
Thank you, Mr. Chair. Three things. First, if we have a few minutes, I'd appreciate if we set aside some time for either Ms. LaFrance or Mr. Weddleton to go through the S version that they have put forward of this ordinance. Second, to Mr. Dyson's comment, my gut feeling tells me that the things that you are trying to put in here, Mr. Dyson, might not fit into this ordinance and maybe should be included in a separate ordinance. That sort of fits into my third point. I belong to a specific community that is a little bit, when you raise these types of issues of trying to criminalize knowingly passing these types of infectious diseases or viruses, we get a little bit hesitant and worried when we talk about these things. So I would appreciate if we don't muddy this particular ordinance up with that and put this in a different ordinance if this is something you want to do.
Thank you, Mr. Rivera. First though, Mr. Weddleton, and for the administration, my understanding is, though it has your name on it, that this is sort of the joint S version from the administration and those two members. Is that correct?
Weddleton here. That is correct. We'd ask for a couple changes. One is just in that public safety definition so that it made clear that Whittier Police would be included. And then someone constraint to the mayor and adding the in consultation with, and it ended up the municipal medical officer. So those are the key things. I had some edits and wording to try to tighten it up a bit. And then some of the suggestions I had got pulled out so it matches state wording more clearly, and that was fine. So those are the key things. But this did come. That was kind of the initial volley. Then it went back to the municipal attorney.
Yeah. So to be clear, we've been discussing the S version. There only is one S version, and I apologize for the confusion about
Correct.
where that was coming from.
That's correct.
Mr. Dyson, you wanted to respond to Mr. Rivera's second point?
Well, I appreciate his sensitivity. This only has to do with emergency situations. And certainly I wasn't thinking at all about the issue that Mr. Rivera, but I am thinking particularly a significant portion of our population we have of people that are really impaired mentally, and particularly the homeless folks who would act irresponsibly and hurt others.
Mr. Rivera, do you have any other thoughts or questions?
Thank you, Mr. Chair. Not at this time.
Thank you, Mr. Rivera. Mrs. Alatel?
Thank you. My question is from the bottom of page 9 to the top of page 10. Starting at 8, it says an isolated or quarantined individual or group of individuals may apply to the Superior Court for an order to show cause why isolation or quarantine should not be terminated. And I would think that individuals or a group of individuals would be applying to terminate their quarantine or isolation. I guess I'm not tracking it with the rest of the paragraph.
Ms. Vogel?
Through the chair, I view that as using the legal term of art. In order to show cause is putting the burden back on the municipality. So you're asking the court to please issue an order requiring the municipality to show cause why isolation or quarantine should not be terminated, if that makes sense. So it follows that nomenclature in other parts of law. In order to show cause is essentially saying, hey, is there any reason, municipality, why we shouldn't be ending this termination?
Yeah, I think we should definitely be putting this in as plain English as possible. I know what an order to show cause is, and I missed it. And this will be applied to folks who are in stressful conditions and stressful circumstances. I think with a lot of these types of processes, particularly where there's a magistrate and, and there's quick orders and ex parte and the rules of evidence are lax, oftentimes I see these play out, particularly in mental health hearings. Well, there are these, here's the rules written in code, and they're often very hard to understand. So the clarity that we can provide is a great service. I think it's one that we need to provide. I know it's not a current amendment that we're under, but if we're going to do this, I think we should be very clear, especially since right now, and until we put it in there, we don't have references for counsel. And some folks won't choose to take even appointed counsel. So I think this is really important. This will be extraordinary relief type law. And to the extent that folks are trying to understand this on their own, I think we really have to be as in plain English as possible. Thank you.
Ms. Vogel?
Thank you, Mr. Through the chair. Ms. Alatal, this is actually maybe answering, and I think it was your question earlier about notice. The two places, and sorry, it just took me a little while, it's a lengthy ordinance. The two places that talk about notice are D4 and G3. Talks about service with the petition and requiring notice about an individual subject to an ex parte order. So I just wanted to be clear that the current provisions do have notice requirements, but your point is taken on wanting clearer references to counsel and more clarity. I think where clarity for the public can be achieved without confusing the court system, we're going to be totally on board.
Okay, so that's it for the queue right now. We have a couple minutes before we need to start the school district. Mr. Mayor, you're here. Do you want to speak to this at all before we move on?
Just very briefly, these are extraordinary times that we're in. I understand that there were some extraordinary comments made about what we're attempting to do here. And I'd just like to assure the Assembly and the people of Anchorage that we are all about making sure that the community is kept safe. We are not about using this as an opportunity to aggregate power to the executive branch, and we're doing everything we can to assuage any concerns to the contrary.
Thank you. And then a note on process. So this will obviously be before us on Friday night. This will be the third ordinance that we take up. I imagine there might be quite a lengthy debate. If it doesn't pass on Friday night, it will roll over until the Tuesday night regular meeting, and we'll have another chance to pass.
Mr. Chair?
Oh, I'm sorry, Ms. Zalatel, you had an issue, and then Mr. Constant?
Yes, thank you, Mr. Chair. I think that we also need to contemplate, as we're talking about infectious disease, a lot of times these processes happen very analog, on paper. It's not electronic. So I just want us to think about that as if we need to make any changes here that would allow us to do things in a different manner. The state courts are still very paper-driven, and what the access to technology might be for anyone who could be subject to one of these orders. So I don't know that I have any specific suggestions right now, but I think we have to weigh that expediency, the considerations of infectious disease, as well as access to the information as we look at this. Thank you.
Thank you, Ms. Zalatel. Mr. Constant, and then Mr. Dyson will
Thank
be the
you.
last word.
Yep. Just a note to the mayor who showed up, at least for my part, there was no argument that this administration was intending to do anything extraordinary outside of the bounds of the written language and reason. But the question was asked, what happens when it's not us at the helm and there's someone else? And are we setting forward a policy that we can reasonably suggest doesn't have unbounded power? And so it certainly wasn't in the context of this mayor and this situation, but we're not writing code for this mayor in this situation.
Just in reply, I would just caution everybody to keep the language and the temperature down as much as possible.
Thank you, Mr. Mayor and Mr. Constant. Our last word will be Mr. Dyson. Mr. Dyson?
Mr. Constant said it very well. Mr. Mayor, there was no heat, no inflammatory comment. It was literally about the concept. And whoever reported to you was overstating it.
Like Mark Twain.
Yeah, thank you.
Greatly exaggerated.
That's right.
Well, no, I did use the word homicide. I mean, that is, to me, the extent of the power that looks to be granted there. So I don't think you were misinformed in that way, but it wasn't in heat, it was in reason that we're asking these questions.
Thank you, Mr. Constant. Okay, with that, we're going to close this work session and move into the school district budget work session.